Hello viewers and my dear students, I welcome you all on my YouTube channel on Indian Contract Act 1872. Today we will discuss free consent part 2. In earlier video we have discussed about the concept of free consent. So word consent derived from Latin word consentire, which means an agreement. Whenever parties are entering into an agreement, such parties must enter into an agreement with their free consent. It means that the consent of the party shall not be caused by pressure or by threatening to them. It should be the will and wish of the parties to enter into contract. It is expected from the parties that they will enter into an agreement according to their will and wish. If an agreement is entered by party under compulsion or under threat, then all such contracts are voidable or void at the option of the parties. So friends, free consent is very important factor for a valid contract. If there is no free consent, we cannot expect a valid contract between the parties. Friends, now we will discuss what is the definition of consent. Section 13 provides the definition of consent. When two or more persons are said to consent when they agree upon same thing in same sense. This is very important thing that according to section 13, every party entering into an agreement must have an understanding between them that they agree upon same thing in same sense. Whatever one party wants to give, same shall be accepted by the other party. It is called as same thing in same sense. So analysis of definition, it requires these essential requirements, that is two or more persons said to consent when they agree on same thing in same sense. It is called as consent. So as per this section 13, consent is very important aspect. Next friends, we will discuss definition of free consent. Now we have to discuss the free consent. What does it mean? Because free consent is basic requirement for a valid contract. Section 10 of Indian Contract Act 1872 provides that all agreements are contracts if they are made by the parties with free consent. So this is very important thing, that the consent of the party should be free. So section 14 provides that consent is said to be free when it is not caused by. So it is said in negative sense that when consent is not free circumstance, it describes certain circumstances under which consent is not free. So first is the coercion under section 15, undue influence section 16, fraud section 17, misrepresentation section 18, mistake under section 20, 21 and 22. So these are the fivefold criteria where consent is not free. When these 5 elements are present in any agreement, such or in under any contract, such contract is voidable or void at the option of the party whose consent is caused so. Now friends, we will discuss what is mean by fraud under section 17. Fraud definition: fraud means and include any act by party to a contract of his convenience or by his agent with intent to deceive the another party or his agent or to include him to enter into a contract. Friends, fraud is an act of parties where it is committed against the other party, and fraud is nothing but there is intention to deceive the other parties. Parties want to deceive and they want to enter that party to enter into a contract. So this is prohibited under section 17. If a fraud is committed against the parties, it means some information is concealed. If there is no necessary disclosure on the part of promisor, then such contract is called as caused by fraud. Analysis of section 17. According to section 17, fraud is defined. So false representation. First thing which is applicable under section 17 is that whatever statement made, it should be false false representation made by the party. If it is false representation, it will amount to fraud. Then such false representation shall be made to deceive the other party. We can say that the basic object of fraud is to deceive the other party. Sometimes deceive is through monetary benefit, for any property benefit, or for any other benefit under a contract. The representation must be made with knowledge of its falsity. For application under section 17, that is fraud, it is very much required that the representation made by the party with the knowledge of its falsity, means person must know that whatever I am giving or promising to give, it is false. I cannot give it, or I may not be the original owner of the goods. Sometimes it should be there. If it is so, then section 17 will applicable. The party must suffer from the loss, and other party must suffer some loss due to the fraud. Then only section 17 will applicable, and it will be treated as a fraud. Landmark judgment. Friends, now we will discuss some landmark judgment on fraud. Dairy versus Fick QB 1889. Friends, this is very landmark judgment of House of Lords, where director of a company stated in prospectus that they had been authorized to run tramways with steam engines, but later the permission was not given by Board of Trade. Shareholders claimed that there was a fraud with them. So this is the case in United Kingdom, and very landmark judgment, and it distinguished between the fraud and misrepresentation. What is fraud and misrepresentation? So House of Lords held in this case that there was mere representation and no fraud, because the statement was without any intention to deceive. It means that the director of companies no doubt stated falsely in their prospectus that they had been authorized to run the tramways on steam engine, but actually they permission have not got. So it was one of the misrepresentation, and it is not a fraud, because there was no intention to deceive the other party. This is very important landmark judgment of House of Lords regarding the fraud. Friends, now we will discuss the misrepresentation under section 18 of Indian Contract Act 1872. Misrepresentation means what? Misrepresentation means misstatement of a fact material to contract. If it is false representation made innocently before or at the time of contract without any intention of deceiving to other party. So misrepresentation is defined under section 18 of Indian Contract Act 1872. It provides that misrepresentation is nothing but it is a statement made by one of the party regarding the material fact of contract. Sometimes misrepresentation is innocent statement made by the parties. There is no intention to deceive. So friends, the basic difference between the sections 17 and 18, that is fraud and misrepresentation, is that under fraud party have intention to deceive, whereas in case of misrepresentation party don't have intention to deceive the other parties. So essential requirements of section 18 is representation made by a party. Such representation must be related to material fact only. Representation must be made without knowledge of its falsity. Means the person who making the representation is not knowing the falsity of the thing, but actually he is saying that a particular thing is true, but actually it is not a true, it is a false. And such presentation for enter into contract. So whatever presentation is given, it is called as a misrepresentation, and it should be to enter into contract. Means there is an invitation to other parties to come into a contract. So this is section 18 where misrepresentation is defined. Important aspects of misrepresentation. Mere silence is no fraud. A contracting party is not obliged to disclose each and every fact to the other party. If a person is to sell his goods, he is under no duty to disclose the defects in his goods. If he make false statement as to goods quality, it would amount to fraud. It is the duty of buyer to be careful while purchasing the goods. So every time, friends, it is not the duty of the person who is selling the things. It is also the duty of the buyer also, that they have to be very careful while purchasing the goods, because they can ask some questions to the promiser, and if the answers are not as per the need of promiser or promisee, then such goods shall not be purchased. So if a promiser keeps silence on a particular aspect, it is not a fraud. Means every time party have to ask some questions before buying the goods, and the promiser or the seller may sell anything when there is a duty to speak. Sometimes or under certain circumstances there is a duty of the parties to speak. They cannot keep silence or keep mum on certain aspects. When the circumstances of the case are such that it is the duty of the person to speak, but when he keeps silence, then it amounts to fraud. So whenever there is a duty to speak, it is the duty of the party to disclose each and every aspect of the goods. If there is a silence, then it amounts to fraud. So sometimes it is the duty of the party to disclose each and every aspect of the goods which is sold under a contract. For example, partnership agreements, insurance contract, trust contracts, contract of guarantee, shares of company. So whenever, for example, we will discuss insurance contracts. Whenever insurance policies are issued to a beneficiary shall disclose all material facts regarding his health, his other aspects of financial position and all things. He have to disclose all these things with the insurance companies. If anything is hidden or concealed, then it is the duty of the party to speak, and it is not a valid contract at all. Now we will discuss, friends, mistake as to matter of fact essential for agreement. Section 20 provides it. An agreement is void where both parties are under mistake as to matter of fact. When the consent of the parties consent is caused by mistake, such contract is void. Mistake regarding matter of fact of contract. Mistake of law. A contract is not voidable because it was caused by mistake as to any law in India. In India, it has same effect as mistake of fact. Ignorance of law is not excusable under any circumstances. So mistake of fact and mistake of law is excusable, or if the parties are under mistake of law or mistake of fact, contract is void. Dularia Devi versus Janardhan Singh, AIR 1990. This is a landmark judgment of Supreme Court of India, where Supreme Court of India held that contract is void because it is caused by mistake. Because a illiterate woman executed gift deed in favor of daughter, a different property was executed. Means A property was going to be a gift deed, but B property was given. So it was a clear mistake of fact, and this is whatever the contract is void. Mistake of law, section 21. An agreement is void if both parties are under mistake. So if, for example, both the parties are selling and purchasing a horse, the seller of horse and purchaser are at one place and horse is at another place, and horse is died due to lightning, and the owner of the horse don't know anything. So this is clear cut matter of mistake of law, and they don't know anything. So contract caused by mistake of one party as to matter of fact, section 22. Now friends, we will discuss the difference between these two aspects, that is fraud and misrepresentation. Intention to deceive the other party. Fraud means intention to deceive the other party. In case of misrepresentation, no intention to deceive. It is also criminal offense. Fraud is a criminal offense. Misrepresentation, it is not a criminal offense. Fraud may be committed even outside India. It is within India only. Fiduciary relationship is not required for fraud. Misrepresentation, fiduciary relationship is required. Section 17 defines coercion. Sorry friends, this is not coercion, this is a fraud. And section 18 provides the misrepresentation. It is not a undue influence, it is a misrepresentation. So thank you friends for your kind listening. If you like this video, please share it with your friends and fellow colleagues. Thank you for your cooperation.